we're now back with the second session of the morning. And next year, on the data security stage, we'll learn how to deal with international data transfers in big data scenarios, understand the challenges, and make the best decision that don't hamper the transfer of personal data. Now, we have with us sharing his experience in the field, Tudor Galos, a versatile award-winning privacy consultant with a growth hacking attitude and almost 20 years of experience in management roles in both local and regional positions. He leads a boutique consulting company working with over 150 customers in various verticals from UK, US, and Europe. Welcome, Tudor, to Bucharest Tech Week, and the stage is all yours.
Thank you very much. Hello, everybody. Thank you for the introduction. It's very nice to see you all here on such a beautiful topic, which is usually hated by everybody, privacy and data protection. Just yesterday, I had a call with partner of one of my customers, and they said, oh my God, with this privacy you are killing our business. And in fact not. And today I'll try to demonstrate you how you can use data protection and privacy as an asset versus as a cost. And you'll see it's all about common sense. First thing first, the advertising moment about us, what is Tudor Galos Consulting. In fact, what we are doing privacy compliance, but through digital transformation. So for us, big data is really, really important. Automation is really important. And of course, exchange of data between different organizations and different databases and data sets for specific scenarios. We are a strong team with project management, legal compliance, management consultants, and so on. We are trying to make all our customers profitable. We are working, for example, with lots of startups who received really good investments. These days, we are really happy. Just a few days ago, one of our customers was sold to a really big company from outside Romania. For us, this was also really good news. So we are striving to do not only compliance, because, by the way, the best compliance you can do is close the company. Okay, so that's perfectly 100% GDPR compliant. So when somebody comes to me and says, hey, Tudor, we are 100% GDPR compliant, I know, okay, so your company is closing. This means you are perfectly compliant. We are working, yes, with over 150 customers throughout the world. US, EU, UK, we just finished a project in Turkey. We are growing constantly, and we are working with a concept which is called privacy by design and by default. And this is really, really tough, because actually you need to put compliance at the heart of the business. Meaning actually all the processes you start designing from that moment need to be privacy compliant. Or let's say it needs to be transparent, needs to have security at the core business. And I really loved the first presentation, because in the first presentation we actually saw how important is security and cybersecurity and data security, because that's driven by your customers. If your company doesn't offer data security, your company is not offering respect to its customers, and at some point these things will be seen, because we are attacked daily. By the way, I have a blog. I don't know how many of you read my blog. And my blog receives around 3,000 attacks a week. Okay, it's a blog, and I'm not a top blogger. I'm down at the bottom. 3,000 attacks per week. So let's get into some terms. First of all, privacy is not an asset. It's an asset, it's not a cost. When you offer privacy compliance, when you offer data protection, you show respect to your customers, to your partners, and yes, to your employees. Oh, I really want to kill this myth. The fine is not the worst thing that can happen to you. The fine is not the worst thing that can happen to you. I have a customer, it's a company who is in services, okay? Media services, management services, And they had a really small data breach, a really simple data breach. Okay, sending an email with everybody in the CC. It happens. It happened to many of you, I think. You all received, I think, mails in which your email was exposed, right? So, well, that's a data breach. We had to report it to the authority. Guess what? It was classified as a data breach. A fine was received, really small fine. One of the smallest fines in Romania. We're really happy. Bad thing. Each RFP this company enters into, each RFP, they are asked, did you have a data breach in the past years? Well, yes. What happens next? Either, thank you very much, either we need to do a really deep dive into your security compliance. So here is a simple questionnaire with 3,000 questions that we expect to get back from you in the next 3 or 4 days. And this happens at every RFP. So yes, the fine is not the worst thing that can happen to you. Losing actually the business and the trust of your customers and partners is. And basically, you need to think on a risk-based approach. And this is really important. When you think data protection compliance or privacy compliance, you need to put yourself in the shoes of your customers, partners, and employees. At ISO 27000 family, for example, the risks are defined from a company perspective. It's security risks, data risks, okay, infrastructure risks. At data protection, you actually need to put yourself in the shoes of your people you're working with. What can happen to them if their data is exposed, deleted, processed inaccurately, wrongfully processed, and so on? What can happen to them? And that's the tough part. You actually need to put yourself in the shoes of the people and start asking questions like, what could go wrong with this? What's really tough is that there are a lot of regulations appearing. I think you've seen them daily. You see new announcements. GDPR was among the first ones. But then we have changes in regulations around the world. We have CCPA and the CPRA in California, CDPA, CPA, LGPD in Brazil. China, we have new legislation of data privacy. UK new privacy law is about to appear. It's being debated. Still, UK has its own GDPR. It's called the UK GDPR. But new legislation appear every, I don't know, month we see a new piece of legislation. Moreover, we have a new data strategy from European Union, which affects big data processing, not only personal data. We have Data Act, Data Governance Act, Data Markets Act, Data Services Act. Oh yes, and we have in discussion an Artificial Intelligence Act. Now, although they are written in legalese, I invite you all to read them. Because for many of them, you can provide feedback to the European legislators. For example, for the AI Act, many of us provided feedback because at the current definition of AI, 90% of algorithms are considered by European Union as artificial intelligence. And you will say, yes, but this is what the market does. You see thousands of companies saying we have AI, and they don't have AI. Okay, they have a simple algorithm, an if-then algorithm. Oh, it's AI. It's a machine performing the calculation. Yeah, clearly it's AI. No, it's not AI. The problem is that if it's being regulated, you need to do some extra steps which are costly. So not everything is an AI. So yes, do provide feedback and do understand what's coming to you. Let's get into some small definitions. Like what the hell is personal data? And I've seen a lot of confusion in the market. And the authorities did not do their homework, which is educating every one of us around what the hell is personal data. Personal data, the definition starts, it's everything that can lead to the identification, direct or indirect, of an individual. Direct identification, hey, this is a photo. Hey, I see George here. Yeah, I know George. Indirect identification. Hey, here is a photo. I don't know any person here, but for sure someone, somebody, or something, like a machine, could identify each person here. And by the definition, everything that could lead to the identification of an individual, not by yourself, can be considered personal data. Like the guy in the black shirt presenting at Big Data Week at around noon, it's personal data because this identifies me. Just this description. Just this description. So the term is quite confusing. A lot of things are personal data. You have a lot of personal data you have no idea about, and you're processing it daily. The complexity is created by the fact that we have also some other regulations in EU. The regulation 2018-1807, it's about the free flow of data around countries inside the European Union, which specifies the following thing. Where personal and non-personal data in a data set are inextricably linked, this regulation shall not prejudice the application of regulation GDPR. In translation, if a data set contains personal data inextricably linked to the data set, the whole data set becomes personal data. Let me give you an example. Car registration is personal data. The registration plate, yeah, is, right? Even if it's a company car driven by 5 people, is it still personal data? The answer is yes. You know why? Because the company needs to know at every moment, legally, who drove that car, when it drove, at what time, and they need to do it by something which in Romania is called foaie de parcurs. Basically, you either have a paper which is clearly signed by the employee saying that he is driving or she is driving that car, either you have this wonderful document specifying who drove it and where it drove it. Okay, so you know. So this means that the registration plate is personal data. To the registration plate, there is another number linked of the car, which is called VIN, Vehicle Identification Number. Both these numbers are on the car registration document, on the license, yes? Well, that one, the so-called Romanian talon, is also personal data. The car documents are personal data. The insurance document, the motor insurance document, mandatory insurance, is also personal data. And all the other documents, the repair documents of the car, are becoming personal data. Welcome to personal data in big data. Okay, so that's the idea. If you have, for example, a list, a simple list of car repairings, those are considered to be personal data because they can lead to the identification of certain individuals using some additional algorithms. Okay, good. So this is related to the complexity. A lot of things are personal data. So coming back, just to give you a graph, to make it simple, if part of a data set, you have personal data, guess what? The whole thing comes up as personal data. Now, the question is, okay, we have personal data. We don't want necessarily to work with personal data, especially in big data scenarios, where, for example, we just need to find key insights. Key insights are performed on certain data sets where you want actually to have some reports, some key reports, which are not necessarily including personal data. Only if you want, let's say, who is our top buyer in the 20 to 30 segment. Okay, you need to process that personal data. But if you want to know, okay, in a certain area, how many people might have above average purchases or above average salaries, at some point you actually could use some de-identified data sets or anonymized data sets to actually perform this report. We'll come back to this. It's anonymization versus pseudonymization. But the big problem here is we are working with these data sets. And I think many of you are working in multinational companies who are working with data sets coming from US or exporting certain data sets to US or to Turkey or to some other countries outside the European Union. Let's see now what exactly are these data transfers. Well, first of all, by a document issued by European Commission, finally, last year only, they define data transfer. It needs to have 3 conditions. First of all, you need to have a data exporter, who is a controller or processor established in the Union. So if you have a company in the European Union that's exporting the data, that's the exporter. Second of all, you need to have the so-called transfer. And here is the definition. The exporter discloses bulk transmission or otherwise makes personal data available. this was a long debate. Is access a transfer operation? And the answer is yes. So for example, if you have some data and you put it on an internal share in your company, and that data is accessed, for example, from the United States, that's a data transfer. The simple access, the simple viewing of the data is called transfer. Okay? So it doesn't need to be taken to the other side. We had a lot of debate, for example, with some startups saying, yeah, but we are not transferring, we are just actually taking the data, de-identifying the data, performing the processing on the anonymized data, and then with the personal data, we are throwing it around. Yeah, but you are storing the personal data. No, we are just for a few milliseconds. That's storing. So you are actually importing the data. You're viewing it, you're processing it, and till you anonymize that data, that's personal data. And this is the issue with Google. Remember the Google Analytics scandal? Google Analytics was forbidden in Austria, Italy, and France. You simply cannot use it. Moreover, this is now running through the binding mechanism of the European Union, so most probably, soon, Google Analytics will be forbidden in the whole of EU. I heard a yes. Well, the problem is that legally, if someone, for example, files a complaint at the Romanian authority, they might need to take the same decision, that Google Analytics is forbidden. And the reason is very simple. That Google Analytics cookie you're putting on your website is actually collecting tons of data that you have no clue about. Yeah, you're being presented as a customer with a dashboard, a nice dashboard. Here are your users, anonymized. You don't know who they are, but here are some reports about them. The problem is that Google is taking a lot of this personal data and flowing it to the United States. Then Google said the following thing. Well, we have an anonymous method by which the traffic is anonymized once it reaches the United States. But the problem is that till it reaches the United States, I mean, those milliseconds, that's personal data processing. So that's a data transfer. Okay, so that's a big risk. Because why is this transfer considered such a big risk? The problem is that the requirement of GDPR is when you're exporting personal data in a country outside of GDPR reach, you must make sure as a data exporter that the data enjoys the same level of protection as it enjoys under GDPR. So you need to take technical and organizational measures, additional ones, such as putting things in contracts, legally stuff, but also technical measures. So this is where things are becoming really sexy and cool for the technological part. The problem is that, for example, you need to take this into consideration. What laws are impacting the transfers? Let's look at EU. You have GDPR, clearly. Yeah. So you need to take into consideration that requirement that this data needs to enjoy the same level of protection in the state where the data is exported. Cool. How do we do that? Well, we'll see we have some transfer mechanisms that we can use, but we need to look at the legislation on the other side, right? Where we are exporting the data. Would you be cool if you knew that your health data is being exported, let's say, to Russia? To China? Would you be okay if I told you that a lot of this data was already exported there? So that's the problem, because a lot of things could go wrong. For example, you saw there were some movies where people were flying to some Asian destination and suddenly they were caught and their organs were cut out. Well, simply because they had their medical data stolen from somewhere. Imagine that your medical data is being profiled and you might be profiled as key donors to people in the Communist Party in China, let's say, or to the regime in Kremlin. Could this happen? No, of course not. All people are good in this world. No one would think at such a thing. But the problem still remains. What is the legislation on the other side? What is that legislation saying? For example, I was among the ones who started a huge debate around Yango in Romania. Remember Yango? When they had, it was a Russian company, very strongly connected to Yandex. Yandex owner is a guy called Arkady, whom I met at, I think it was DLD Tel Aviv. And this guy was actually, he said he was a dissident, he was not close to the Kremlin regime. Well, since then some things changed, let's say politically also in Yandex. Yango was in Romania, and they implemented a very cheap system saying, yes, now we are protecting the data at GDPR-wise. We have a registered company in Netherlands. All this data that we are collecting here stays in the EU. Some data might get to Russia, but Russia is a democratic country. Everything is good. This year, the Russian legislator passed a legislation which is allowing Russian FSB to collect data directly from a Russian service provider, electronic service provider, related to all citizen data and all personal data that is residing on their servers. In this case, Yandex and Yango. So all the data of the people who traveled with Yango cars are now available to FSB. Because this is the legislation. This thing, so this legislation review created a huge issue in the relationship between EU and the United States, which is opposite, let's say, to Russia, right? They're on the good side. The problem is that the US have some very strong surveillance laws, which is allowing US authorities to request electronic service providers in the US to handle them data which is residing on their servers. And with the addition of the Cloud Act, it allows US authorities to request data from US electronic service providers, which is on non-US servers. So yes, US authorities can seize data of European people, which is residing in EU servers owned by those US companies. And all the companies, Amazon, Google, Microsoft, all of them are subject to this law. This is why the famous deal between EU and US called Privacy Shield was cancelled by the European Union Court of Justice. So at this moment, exporting data to the US is somehow at the limit of legality. So that's a big issue, and I'm not kidding, with cloud providers, with everything. So you need to take into consideration what additional measures can you take. And we'll see an example right in the next slide. Then you need to establish who exactly is the data exporter and who exactly is the data importer. It sounds easy, right? Well, if I'm exporting data, I'm the exporter. Well, if that company is importing data, well, that's the importer. The problem is the data flows both ways. So you need to establish exactly who is the exporter in the deal and who is the importer in the deal. Next, what happens if people complain? Suddenly, you realized that Yango tricked you. And now FSB has your data. And you want to legally exercise your right to deletion of data, right? Who is accountable? And I love this term accountable because it's like the Romanian word door. It's very hard to translate. It's somehow around responsibility, but actually it's not responsibility. And this accountability is a very strong word because it means that person is responsible, but I'm going to hold that person accountable for what he's doing. So basically, someone's head is falling due to this issue. That's accountability. It's responsibility with some heads falling off. Who is accountable now that the data has been exported to Russia? Because right now, let's say I'm at risk. Some people in FSB might know what I'm doing, where I'm living, whom am I visiting, where is my lover residing. All the data is in the computer. Okay? If I traveled only with Yango, that would know some key destinations in my routes. I know people are asking, but what would they do with my data? Profiling. knowing exactly who is staying with whom, who is moving where, and so on. Then, access. Who has access to transfer data? Is it just the importer? Is it the importer employees? Is it the importer's suppliers? The authorities? Who is having access to this data? How sensitive is the data being transferred? Again, health data. How often is the data transferred? Is it continuous? Is it one time? What are all the risks towards data subjects? For example, you are using some US software and suddenly you are invited to the United States. And when you arrive in the United States, people at border control stop you and take you to a room. Have you seen the documentaries at National Geographic with people taken to a room by the US authorities? They might stay in that area for 1 day, 1 month, so on. Why? Because the system profiled them as high risk. Why? Who had access to your data? What went wrong? How is this possible? And of course, why is the transfer happening? What is the purpose of the transfer? What is the legal ground for transfer? So this is really important. Now, the key thing that you need to know when you're exporting data sets outside of the European Union, again, you need to offer the same level of protection as it is offered under GDPR. And then taking you to an example in France, where, for example, they had an application, a system called Doctolib, which handled vaccination in France, which was hosted on Amazon servers, but on Amazon servers in EU. Well, in France, there are a lot of course, consumer rights NGOs, and they protested and they filed some legal complaints in the court of law saying this data is not protected because in 2020, the privacy shield mechanism for transfers between EU and US was cancelled due to the fact that the US authorities had access to this data. This data is very sensitive data, it's health data, needs to be protected, so this should be on French servers, not on Amazon servers, even if they are in France. Well, and Doclib demonstrated the fact that they took the necessary measures to protect the data. What did they do? They encrypted all the data on the Amazon servers with a key which was residing on French servers. This is a mechanism called BYOK, bring your own key. Okay? And it's quite safe to transfer data, I don't know, around the world, let's say, using this mechanism because it's your key. Okay? In theory, your key shouldn't be exposed, in theory. But this is why, and I love the fact that Florin talked about homomorphous encryption. It's one of the best privacy-enhancing technologies or PETs available at this moment. It's still in research mode, so don't put all your money into it, but it's a very, very cool technology that allows you to protect data sets in front of these data transfers. However, BYOK doesn't always work. You cannot work with encrypted data. That's the truth. You need to decrypt data in order to process it, in order to realize your reports, in order to append the data, in order to enrich the data. You need this mechanism. You cannot use only encrypted data. This is why using the so-called PETs, or privacy-enhancing technologies, like homomorphous encryption or differential privacy, are key to big data scenarios. But we won't cover these today because we will need a month to cover all these technologies. We are working on them with some of our customers. But bear in mind that you need to protect the data at the destination as you protect it here at home. Because sometimes using the simplest technologies might be challenging. Zoom, remember Zoom? Remember this scandal? At some point, Zoom realized that their traffic was rerouted through China. All our conversations on Zoom were rerouted through China. China, which is not quite so a democratic country at this point. Okay, it's not very aligned to the European values of privacy and individual freedom, okay? And the calls were rerouted through China. The CEO and the management team of Zoom quickly dismissed the allegation, saying, yes, yeah, it's true, we repaired, no sensitive data was exposed, everything is good. Still, the problem is what data was stored there, what the data is being saved there, how much of the data was leaked, how much of the data was decrypted, what do they know about us? Because all of us here in this room, I think we were on Zoom. Some of us still are, but the idea is that still the issue is there. And I want to bring up this challenge because whenever you are transferring data, you need to look at the whole context. Because a simple Zoom call means actually you are accessing a service which is in the cloud in the United States. You're transferring data there, which should be encrypted, okay, but you still see the names of the participants, you still see their emails, you still see their reactions, okay? So there are supplemental data points. Zoom is also generating a lot of metadata, okay, data about data. They are looking at you when you're pressing heart, when you're raising a hand, when you're actually raising a hand, what is the context, what words were they said there. Remember that issue with Zoom mute? You know the Zoom mute issue? You're putting mute on the Zoom, right? Do you see that when you start talking, it appears something on your screen, you're muted? Do you know what technically this means? That Zoom is still listening to your microphone. Your microphone isn't physically muted, isn't muted at all, in fact. The other participants can't hear you. Zoom application knows that you talk, so it has access to the microphone, okay? So you need to understand these things because that data can get transferred to that service, and you need to clearly say this to your data subjects that, hey, yes, we are making a Zoom call and your voice is continuously being transferred once you click the attendance, even if you mute your microphone, yes? Unless you hardware mute your microphone, okay? Yes, I have a microphone with switch, which I'm using. Yeah, then that data is being transferred. And this is a personal data transfer because actually you have a lot of data there, okay? And again, it's a lot of metadata generated. So you need to explain this to your people. What happens when you transfer this data, when this data is being transferred to the service? Now, I told you about regulations, and I told you about the fact that you actually need to analyze the regulation on the side where you are transmitting the data, or the side that is accessing the data. This is quite simple. So, these are some of the regulations around the world. Now, some key specialists did an amazing work, and they did what is called alignment of regulations. This is the address. In fact, it's Global Comprehensive Privacy Law Mapping Chart, or Privacy Law Mapping Chart. If you Google it, you'll find it immediately. And you see actually different alignments between key things. For example, right to access, right to delete data, right to redress, right to portability, and so on. All these are aligned and already for you to use it in order to know exactly what rights are in that legislation and what rights are not. But the problem still remains in scenarios like multi-geo data transfers. What happens when you're processing data from EU and combining it with data from US, with data from Australia, and so on? With South Africa, let's say, because it also in South Africa there's a big issue these days with the privacy data legislation. Now, the problem is that you need to make an alignment, okay? From a documentation perspective, things are really complex. You need to put there a lot of things, such as standard contractual clauses with multi-tenants, multiple partnership, and so on. I won't get into all these things. First of all, the first question that you need to do, you need to ask, whenever you're performing a transfer or even simple processing of data, and I'm asking this, I'm always asking this at our customers, do you need to do that? Why? Tell me why. Tell me why do you need to do this? Because usually this is what an audit means. Actually means asking the tough questions. Because this is when people start, yeah, why are we doing this? A lot of times they discover that they don't really need necessarily to do this. It's like they got used to it. Yeah, it was simple tools. Yeah, we use them, we are paying with our data. What can go wrong? Till things start to go wrong. This is why you need to use the so-called data transfer legal mechanisms. Now, whenever you're transferring in GDPR, you have three options: adequacy decision, appropriate safeguards, or derogations. Adequacy decisions means European Commission already signed documents with that country, let's say with the US, and well, not yet, US is not a good example, Israel, for example, okay, where both countries can exchange data between themselves, both regions can exchange data between themselves, just like that country would be a member of EU. With UK, for example, people ask me what happens now after Brexit. Well, you can still exchange data with UK entities, just like UK would still be in EU, because there is an adequacy decision signed between European Union and UK. Okay, it's the same with Israel, let's say, and other countries. With the US, President Biden's announced a new transatlantic data framework initiative by issuing a few executive orders in order to establish the new partnership between EU and US. So soon, most probably next year, in March 2023, April 2023, we might have a new deal for adequacy decision between EU and US transfers. If you have an adequacy decision, sorry, you don't need to do anything additional, okay? Just standard documentation. The problem is with appropriate safeguards. Let's say you want to export data to Serbia, okay, or Turkey. What do you need to do? Well, things are becoming more complex then. Do you have a GDPR certification? The answer is no, you couldn't have, because, well, guess what? There is none yet. Great Brussels bureaucrats did an amazing job. We still don't have a framework for certification in EU, and no certification available across EU. Then another mechanism is the so-called adherence to a code of conduct. We have this. We have a new cloud code of conduct issued last year, COC, okay, where Microsoft, Amazon, and others adhere to. It's really nice. A code of conduct is a set of best practices and a set of controls. It's a matrix of controls which are software. For example, if you're working in a software as a service company, or platform as a service, or infrastructure as a service, if you want to adhere to this code of conduct, you can do this, but you need to follow exactly by the rule all the controls, such as ensuring separation of tenants and so on. SCC, standard contractual clauses. This is the most used mechanism. It's a contract template issued by European Commission, where you cannot modify the first part, you can work on the annexes. And in the annexes, you need to describe, of course, who is the exporter, who is the important purpose of the transfer, what is the personal data being transferred, who are the data subject categories, whose data is being processed, and this is really important, additional mechanism to address all the risks related to the transfer. What happens is that if you as an exporter, you don't address the risks related to the data subjects. For example, if you're exporting data to Russia, let's say, well, if something bad happens to the people due to that transfer, you as a data exporter, you are liable to damages to that data subjects and, of course, to the authority in forms of GDPR fines. Okay, so you need to take measures, specific measures, and really specific measures, not generic, like, yeah, we have security, we are 100% GDPR compliant, I swear. We are testifying that we are 100% GDPR compliant, and yes, we have some encryption. What encryption? TSL, which type? Doesn't matter. So that's the discussion. You need to have specific measures to address these risks that the data of people might be misused. Then you have BCR. Usually these are used only for intra-group agreements. So if you're part of a multinational company, BCR is binding corporate rules, which is a document which needs to be approved by a supervisory authority, and it becomes the Bible of how you transfer data inside your organization. Those are the best, those are the hardest to approve. Around 3 to 5 years for a BCR to get approved, so it's not very feasible. But what you need to do when you're transferring personal data outside of EU, you should perform again, this is not mandatory, it's recommended, you should perform a TIA, Transfer Impact Assessment. PIA means Privacy Impact Assessment, DPIA, Data Protection Impact Assessment, LIA, Legitimate Interest Assessment, and now we have Transfer Impact Assessment. Luckily, there is a guy really passionate who developed freely, and you can use it, this, so it's David Rosenthal, you'll Google it, it's an Excel file with examples on how to assess a transfer and the risk related to this transfer. Actually, the question you should ask to the person performing the processing. Since our time is getting shorter, let's take some key takeaways. First of all, make sure you map all your personal data processing operations, because a transfer is a personal data processing. Here, you actually need to be very thorough. You need to get into details, really keen details. Yes, make sure you understand everything that is happening behind from a technical perspective, especially in big data where, well, guess what? We are processing large quantities of data. Check who has access to personal data and why. I hear a lot of times that, yes, the headquarters in the US need to have access to the personal files of employees in Romania. No, they shouldn't. Okay, and I hope I'm not breaking any relationships here, but no, they shouldn't. Okay, why would they have access to specific information in your personal files? Check how the person can be affected by the data transfer. Check the laws of the exporting countries and of the importing country. Check how they can exercise their rights in accordance with all the laws. They have rights. You are protecting their rights. And yes, you should perform a data protection impact assessment if the transfer can generate significant risks to the freedoms and rights of the data subject. And part of the DPA, you perform the so-called TIA. But that's a technicality. Most important things here. Ask if you don't know. Seek advice. These are my contacts. Connect with me on LinkedIn. I put a lot of resources. I just put something really cool related to the death of passwords. I want to see passwords. But that's my war. Okay. Connect with me on LinkedIn. Check out my website. Connect with me on Facebook and so on. And I don't know how many seconds we have for questions. Thank you very much.
Thank you, Tudor. Thank you. Now, do we have questions? Maybe one question for Tudor before the next talk?
Yes.
Hey, thank you for your presentation. My question is all this bureaucracy helping really solving the problem, or is it just bureaucracy? I mean, do you really feel that your data is safer in Romania or in Hungary, for example, than in US?
Good question. The answer is it depends what data and how. I worked a lot of years in an American company, and I've had colleagues of mine whose data was seized at the border of US. Basically, their laptops, and they found on their laptops certain things, and they stopped it because, well, guess what? US authorities can do that. So imagine if they can spy on you using that data and actually take decisions of you, because that's the problem of AI and machine learning. They take automated decisions. So suddenly, you're flying in the US, and whenever you are flying, you are being questioned. So yes, things could go wrong. Is it working? Certainly not, because the authorities, all the supervisory authorities in Europe are understaffed and under-budgeted. They cannot do their job. For example, there are thousands of complaints weekly in Romania. They have 30 people. They're handling only some specific companies. Okay, many of the complaints are completely ignored. Many of the complaints are still addressed. So Romania is the third authority, for example, in EU in terms of numbers of fines. So they are quite efficient. No, but it's not working. Also, GDPR should be updated, because now with the emergence of new technologies and new algorithms, it should be updated. The British are doing a great job here. They're issuing a new regulation. We've seen some of the directions they want to involve in. I think we can learn as Europeans from them. They simplified some documents, and I'm fully in line with them in terms of transfers of data. For example, they don't have SEC, they have IDTA, International Data Transfer Agreements, which are much simpler than what we have here, okay? But yes, the things must be improved on all directions. But since privacy compliance is an asset, you shouldn't do it just to be compliant with the law. You should do it to actually show respect and trust to your customers, partners, and employees.
Thanks a lot.
There we have another question. Sorry, don't shoot me.
Thanks for the presentation, Tudor, really
Thank you.
insightful. So you presented that if a single data set is somehow in your warehouse, it doesn't matter, then all the data belongs to like privacy.
Only if it's inextricably linked. Because sometimes you can delink certain data, okay? Or if the data still makes sense without that personal data points, then you can separate it and you have a fully anonymous data set.
So concrete example, I have, let's say, a listener, and a listener, like it's listening for a stream, podcast, doesn't matter.
Yes.
And then I know its demographic, let's say.
Yes.
Right? And let's say I remove all the listener data.
Very
Do I still consider the data set as
Very good question. I wish I had more minutes. There is a study it was performed by the Imperial College of London in 2019, so right before the pandemic, which demonstrated the fact that that an algorithm was able to identify all the citizens of a certain US state, I think it was the state of Arizona, just by 15 data points, which were not related to the name, surname, phone number, or email address. They were all related to demographics. So just by 15 data points related to demographic, they were able to identify 99.5%, okay, of people that was the accuracy. So the question is, from that data set, in order to make it really anonymous, how much should you remove? What are the data points in order to reduce the probability? Because you won't have 0% probability of re-identification. That's the truth. Full anonymization is not anymore possible. But when should it be okay? When it's like 30% to 20% probability of re-identification, this is how you should gauge this. But it's a long, long answer. And we don't have the time.
Cool.
Sorry.
If you have any more questions for Tudor, don't hesitate to reach out to him in our coffee breaks, in the lunch break. You also saw his Twitter and Instagram and Facebook accounts.
Yeah.
Thanks a lot.
Google me, Tudor Galos. Thank you very much.